Now, the flip side of that is civil liberties. These are protections from the government, limits on government power. So what liberties do we have? We have freedom of speech, freedom of the press, freedom of religion, right? These are also written in the Bill of Rights. The First Amendment outlines 5 liberties we have, right? Freedom of religion, that has 2 parts to it. The Establishment Clause and the Free Exercise Clause, right? So those 2 clauses refer to our freedom from the government in terms of our religious practices. We also have freedom of speech, right? And we know that a lot of speech is protected. Most speech is protected, in fact. There are very few types that aren't. Speech that is intended to defraud is not protected. Speech that is intended as an incitement to violent action is not protected. Obscenity is not protected, right? And we know that obscenity and pornography are not the same thing. But obscenity is not protected while pornography is. We know also that a lot of symbolic types of speech are protected. For example, burning a flag is protected as a type of free speech. Also, protesting outside soldiers' funerals is protected as free speech. The Westboro Baptist Church used to do that a lot. They may still do it, I honestly don't know. But there was a while where they were protesting outside graveyards every time there was a military funeral for a gay soldier. So, obviously, this upset the families, but ultimately the Supreme Court said that as long as they're not trespassing on private property for these protests, they can't be limited because these people have freedom of speech. Just like the Supreme Court upheld the right of Nazis to march in Skokie, Illinois. It wasn't that they necessarily agreed with the Nazis. In fact, their ruling said emphatically that they did not, but that we protect their right to speech, that one of the founding principles of our government is that all speech will be able to be spoken, and the best speech will win, right? We talked about this really early on in our sort of political theory discussion at the beginning of the semester. I said something about the marketplace of ideas. I said that technically in that conception, it hadn't been around yet. We saw it more Hume's idea of competition. The marketplace of ideas is Mill's turn of phrase, and Mill was later than the Constitution. But basically, that's what the court relied on here with protecting Nazi speech, that the marketplace will win and better speech will outspeak the Nazis. And maybe they were right, since the Nazi march never ended up happening. Now, we also have freedom of the press, right? Freedom of the press is, again, extremely extensive, even more extensive than free speech. Freedom of the press really only has one major exception, that the press cannot publish troopship movements, right? They can't do anything that would reveal where troops are or endanger them. Now, this has generally been sort of stretched into national security exceptions, but these sometimes end up argued on a case-by-case basis, and we can talk about this more on the day when we talk about media. If you all end up having questions on the Pentagon Papers, we can discuss it. Now, the last 2 liberties that we have in the First Amendment, assembly, that one ends up being considered under free speech cases. Just because when you assemble, you speak, right? And petition, there aren't many cases on this. Why? Because the government actually doesn't have to do anything with our petitions, so why prevent us from petitioning them if they don't have to respond anyway? Now, these rights, we know that the federal government must protect them, right? These limit federal power, but they also, since the process of incorporation that was prompted by the 14th Amendment's passage, since that process, started taking place, we know that states now have to uphold these limits as well, right? They have to guarantee these freedoms from the government for us too. Now, one freedom that we seem to have but is not actually explicitly listed is privacy, right? And we know that privacy is protected because a Supreme Court decision, Griswold versus Connecticut, told us that privacy was protected. And this ruling was actually about whether or not married couples in Connecticut could or could not use, of all things, condoms when they were sleeping together as married couples. Griswold was the head of a Planned Parenthood up there and started teaching lessons on family planning, and she was arrested for basically providing this information to help these people break the law, because there was a law in Connecticut that said condoms were illegal. And obviously, that one's pretty hard to enforce. So what you do is you prosecute people for providing information that would lead to such illicit activity. So the Supreme Court said that there's clearly a right to privacy within the marital bedroom. Not too long after, in Roe v. Wade, they extended this right to privacy, this time with respect to a different reproductive issue, right? They talked about abortion, and they said that ultimately we have privacy in our own medical decisions and in our own bodies. Now, clearly, these two cases are important, as is Marbury versus Madison. Some other cases that could be important would be listed on our old slides. If they are not written on a slide somewhere, I cannot imagine I will talk about them. That said, there are some interesting cases that we may not have been able to talk about in class. So I just want to take a brief moment to discuss two cases that illustrate a really interesting example of how the court can change their mind and, surprisingly enough, can act quickly. Right? It takes usually a long time for cases to get all the way to the Supreme Court. It's one of their weaknesses. They are very slow. But as it happened, two cases that were very similar came up through the courts only a few years apart, and the court, with almost the same composition of judges, ruled very differently. The first case was Gobatis, and in this case, what had happened is Jehovah's Witnesses, remember we talked about them with Chaplinsky, they were quite persecuted at the time. Jehovah's Witnesses can't pledge allegiance to the flag. It's considered worshiping a graven idol. So they sued to not have to salute the flag in public schools, because saluting a flag in public school seems awfully like establishment, right? And even preventing free exercise of religion. So they sued, and the court said that actually there is a compelling public interest to maybe allow this small encroachment on your freedom, because we're at war. This was World War II. It was just after the fall of France. And in fact, his clerks later wrote that they called this decision Felix's Fall of France decision. Felix being Felix Frankfurter, one of the Supreme Court justices, and the justice who wrote the majority opinion for this case. He said that we should be able to enforce some sort of national unity at times of war. Now, only a few years later, still during World War II, the case West Virginia versus Barnett came to the court. And this was about the flag salute, not just the Pledge of Allegiance. So they were very slightly different. But in this case, the court did actually explicitly say we were wrong last time. And of course, it is a fundamental principle of our country and our freedoms here, protected by the Constitution, that we cannot force people to say something that is against their belief system, right? And saluting the flag would do that. Again, I believe this was another case with Jehovah's Witnesses, though it may have been a different religious denomination at that point. And they said, no, You know what this looks like? Forcing young children to salute a flag? Kind of looks like what the Nazis are doing with the Nazi youth, forcing them to put the flag above any other belief that they might have. That seemed somewhat problematic near the end of World War II. So the court said that as important as national unity is, it is more important that we uphold our fundamental constitutional freedoms and that we allow children to express their religion in the way they feel comfortable, and that also means not forcing them to express things that go against their religion. Now again, right, we didn't even talk about these in class. These will not be important enough cases to come up on the exam itself, though they illustrate a very important concept, that as weak as the court can be, as slow as they can be, they can, when they wish, potentially, if the right cases come up, act somewhat more quickly than we would expect. And pretty much they alone, can reverse their own decisions, right? A lower court couldn't have done that, but the Supreme Court could. And they had the power to choose whether to take that case or not. They could very easily have said that the lower court needed to decide Barnett based on the precedent set in Gobitis and left it alone. So they do have some ability to change their minds. But unlike Congress, who could have passed a bill the second they did, or the president, who potentially could have issued an executive order the second he changed his mind, the court did have to wait for another case to come to them. So just to reiterate, most of the cases that are important in the ways that they illustrate other concepts about the courts. But we do know that Griswold and Roe are important. We do know that Marbury versus Madison is important. And we know that other cases, things like McCulloch versus Maryland, right? Other cases that showed up on the slides might be important. And the cases that actually came up on your quizzes throughout the semester, those likely are going to be important, right? Marbury versus Madison, McCulloch versus Maryland, those aren't specifically civil liberties cases. But in this case, in this instance, I'm talking about Supreme Court cases generally and which ones are important to our course.